solicitor's exam in 2002 at the first attempt. So that's a great achievement. And she's a managing partner, Gandhi. She practices basically real estate and conveyancing. So she's an expert in the field. And I think you guys will learn a lot from her. She has made a wonderful PPT. I've had the chance of having a glance at it. And it's really informative and wonderful. We'll of course put the PPT on the website and all. So it will thereafter be available and we'll be recording the session. So that will also be put on the website. So that's basically it. And I'll give it over.
Good evening, everyone. First of all, kudos to everybody who have the guts to give this kind of an exam. Of course, everyone has to work very, very hard. We are here to support you, make things a little simpler for you, but of course, there is no substitute to hard work. Anyways, we will start with agreement for sale and investigation of title. Those are the topics that I'm going to cover today. Let's start with what exactly is conveyancing. Anybody would like to shed some light on what conveyancing is? No one? Nobody wants to give a shot? Yeah, let's be a little interactive. Sure.
Conveyancing in one word, we can say transfer.
Okay, to a certain extent, yes. Anyone else? So, conveyancing is basically the practice of documentations of transactions of transfer. So what you said is correct, but it is basically the practice of making the documents and of transfer, and also so far as properties are concerned, how to ascertain title, what is marketable title, all of that comes under conveyancing. Now, what is immovable property? That is one of the main topics that will come under conveyancing. Everything is essentially revolved around immovable property. What is immovable property? Anyone?
I think we need to respond. Whatever little you know, you will learn more. Otherwise, you'll get bored if it just goes on.
Yeah, I don't want to just go on.
Properties that are attached to the ground.
So basically, yes.
Yeah, that's
so it is basically land and everything that is attached to the land which cannot be removed. So if you see the three essential acts that we looked at under conveyancing are the General Clauses Act, which you will see here, Registration Act and Transfer of Property Act, so far as the definition of immovable property is concerned. Let me just read it out for you. Under General Clauses Act, Section 326 states that the term shall include land, benefits to arise out of land, and things attached to the earth or permanently fastened to anything attached to the earth. Under Registration Act, Section 26 states that immovable property includes, now this is an inclusive definition, land, buildings, hereditary allowances, rights to ways, lights, ferries, fisheries, or any other benefit to arise out of land, things attached to the earth or permanently fastened to anything which is attached to the earth, but not standing timber, growing crops, nor grass. Under Transfer of Property Act, Section 3 states that immovable property does not include standing timber, growing grass, crops, or grass. So basically anything that you can detach or remove from the earth is not included in immovable property. When you talk about transfer of immovable property, what you are really talking about is not transferring the property physically, but you are talking about transferring the bundle of rights that are attached to those properties. So what bundle of rights are attached to the property? Rights like when you own a property, what are your rights? You have a right to enjoy and use that property. You have a right to sell the property. You have a right to bequeath the property. You have a right to get income out of the property. You have a right to say, stop somebody from entering into your property. You have a right to create a covenant running with the land. These are all rights that are attached to the property and that will go along with the immovable property. Then let's come to all the essential acts that we cover under sale of agreement for sale and sale of property. You have the Transfer of Property Act, of course, which is the most important. Then you have the Indian Stamp Act. You have the Maharashtra Stamp Act, you have the Indian Contract Act, you have the Income Tax Act, Registration Act, RERA, that is Real Estate Regulation and Development Act, Maharashtra Ownership Flats Act, which was originally MOFA, which is now partially not being practiced because of RERA coming in. Then you have Maharashtra Apartment Ownership Act, you have Maharashtra Cooperative Societies Act, Maharashtra Rent Control Act, Maharashtra Public Trust Act, Maharashtra Land Revenue Act, COCA Code, personal laws, that is if depending on what religion you follow, you have personal laws so far as succession is concerned. You have the Goods and Service Tax Act and you have the Specific Relief Act. Now let's move on to sale and contract of sale. Now what is a sale of an immovable property? Sale is the transfer of ownership in exchange for a price paid or promised, or part paid and part promised. So when I am selling a property, it is not necessary for me to pay the entire consideration on the spot. Like if you go to a grocery store, you will pay the entire consideration on the spot. But there are times when you are, say, for example, selling a land. You are not getting or not paying the entire consideration today. You are paying part consideration and the balance is deferred to a further time. Also the consideration may be in terms of money and in terms of say area or including time. So portion, monetary portion you may get today, area you may get later. So all of that is included in a sale. How is a sale made? Such transfer in the case of tangible immovable property of the value of 100 rupees and upwards, which obviously for most immovable properties today it is going to be, or in the case of reversion or other intangible things, can be made only by a registered document. In case of tangible immovable property of a value less than 100 rupees, such transfer may be made either by a registered instrument or merely by delivery of the property. So essentially, in Bombay, obviously all movable properties are more than 100 rupees. So all documents of transfer are required to be duly stamped and registered. The stamping will happen under the Indian Stamp Act. Registration has to happen under the Indian Registration Act. Then, delivery of tangible immovable property takes place when the seller places the buyer or such person as he directs in possession of the property. Needless to say, when you are selling the property, you have to hand over possession of the property to your purchaser. Okay, so that is when the seller will hand over the property to the purchaser or to any other person that the purchaser says, okay, you hand over to so and so forth. What is a contract of sale for sale? A contract for sale of immovable property is a contract that a sale of such property shall take place on terms settled between the parties. It does not of itself create any interest or charge on such property. So basically a contract for sale is a document where you are saying that the vendor is agreeing to sell to the purchaser on certain terms and conditions. It is not an actual transfer. The transfer will happen by what is known as a deed of conveyance or a sale deed or a deed of transfer. Now what are the essentials of a valid sale? Now this is, if you think of it, although people say law has no logic, but fortunately for us, our documentation does have a logic. So when you are drafting an agreement, you have to think logically in a certain chronology and draft your document. What are the essentials of a valid sale? First, you have the parties to the sale. Then you have to ensure that they are competent to contract. Then you have your subject matter of sale. Then obviously you will have the price or consideration. Then comes the delivery and then the registration of the sale. This you can always, if you go back to what I just said, so far as the definition and the meaning of contract of sale is concerned, you will easily be able to identify the two and get that in chronological order. Once you have this, I'm also talking in terms of the way you can study. You have these points in your head as a mind map. You can figure out how to even draft your agreement because you know this comes first, then this comes, then this comes. Okay. Now, what is an agreement for sale of immovable property? Anyone would like to answer? What is an agreement for sale? Somebody give it a try.
An agreement for sale is a contract entered into by a proposed transferor and a proposed transferee whereby they are setting out the terms and conditions of the activity.
Brilliant. That's excellent. That is exactly what an agreement for sale is. It is a formal legal contract between the vendor and a purchaser that outlines the terms and conditions under which the vendor agrees to sell and the purchaser agrees to buy immovable property. The agreement specifies key details such as, can you tell me what, without looking, what do you have in your agreement for sale? I just said all of it.
Consideration.
Yes.
Property.
Parties to the agreement.
Yes. I can't hear.
Subject matter.
Subject matter.
Timelines.
Timelines. Delivery of possession. Excellent. Anything else?
Encumbrances that we have.
Encumbrances, yes. Those would be conditions precedent or any obligations of parties like removal of encumbrance. Anyone else?
Representation.
Representations, very good.
Termination.
Yes, termination.
Sometimes it will improve as to how the vendor got the land.
Yes, that is your recital portion. I am coming to that. Yes, it will have the history as to how the vendor got the land. So, all of you are correct. I need this one. Now, why do you enter into an agreement to sell? You can always enter into a conveyance straight away, right? Or you can always enter into a sale deed. Why do people then enter into an agreement for sale? Any guesses?
There will
Yes.
be some condition precedents and condition subsequent.
Yes.
They enter into agreement for sale.
Can you stand up and I can't
So there must be some condition precedent before the conveyance or to enter into the sale deed, and there must be some condition subsequent also after the agreement for sale if they enter into.
Correct.
So because of that they think of they choose or they decide to enter into agreement for sale because there's more you can get it registered also, and still you can have certain condition precedents when you complete it you can again go for conveyance like this.
But why will I not go straight for a conveyance? Why will I enter into an agreement?
So
I can always finish the conditions precedent and enter.
like condition precedents like title search, public like the title investigation. There must be some mortgage if they want to have the mortgage to be removed or something. There must be NOCs, society NOCs or planning authority NOCs, or there could be any condition. It depends upon from transaction to transaction, but there can be any condition precedents wherein the purchaser and vendor both want certain kind of security, but not the title is passing. Like there is no title passing.
So the essential reason that you enter into an agreement for sale before your final document is to bind the parties and clearly set out the terms so that nobody can back out, and if they do, you can enforce the agreement. The compliances, the obligations are all set out in the agreement, and then it becomes binding on both the parties. So an agreement for sale is generally entered into by the parties to legally bind the parties to the agreement and crystallize the terms of the transaction to avoid any dispute in future where certain obligations or investigation of title are yet to be complied with. Also, sometimes, like she said, permissions, consents, etc. are required. Permission from societies may be required, or if it is a property owned by a charitable trust, then you need permission from the charity commissioner, or there may be an existing loan which needs to be repaid. So these conditions precedents you incorporate in the agreement and you bind both the parties, and thereafter, after the conditions are complied with, you enter into the final document of transfer. Now let us look at the structure for the agreement for sale. Now here again we go back to what are the essentials of sale, and you will realize that it just follows that. The first thing that any agreement starts with is the nomenclature, place, and the date of execution. So as you all must have obviously already seen, the agreement will start with this agreement for sale, or this, or even a final document for that matter. This deed of conveyance is made and executed this blank day of blank at blank, where you will put the city or the place where you execute. Thereafter, you have the parties to the agreement, which will be seller and buyer. And also sometimes you have confirming parties. Sometimes there are other parties who may not be the seller or the purchaser, but they have some kind of interest in the property. In that case, you make them confirming parties to confirm your transaction. Then of course you have your expression clause, which is the clause that includes various other entities in the definition of the vendor. Like for example, if you have an individual vendor or an individual purchaser, that would include his heirs, executors, administrators. If you have a society, it would include the committee, the members, their successors. If you have a company, it would be successors and assigns. So you have the expression clause. After which you have your recital. Like you said, the history of the property would be in the recitals. So any document is separated by the recitals and operative portion. Your recitals are essentially the title flow of the property, short history of the property, and a background of how the transaction was entered into and how the parties have arrived at the transaction. And thereafter your operative portion is always the terms. You are not to put the terms in the recitals, and you do not normally put history in the operative portion. That is how you differentiate. So when you are reading a document also, the essential terms are all in the operative portion. Now recital, of course, like I said, it is this part that contains the history of the immovable property and the transaction, and it may include narration including history of title and title flow, parties' intent to enter into the agreement, any preliminary negotiations or discussions between the parties, and the reasons for entering into the agreement. Then what separates the recitals from the operative is your testatum clause. This is the formal statement that the parties have come together and executed the agreement. It could be a phrase like, now therefore in consideration of the premises and mutual terms hereinafter contained, the parties agree as follows. And thereafter comes your operative portion. In the operative portion, which is actually the heart and soul of your document, all the main terms and conditions of sale are set out. These clauses would include the actual agreement to sell. So you will say that the vendor has agreed to sell to the purchaser. Your property description will then come. Then you will have your consideration, which is the sale price, your payment schedule, and the payment terms. And what would you put under the consideration and payment terms? This would have your actual total consideration, which, like I said, could be monetary or in kind in terms of, say, constructed area or any other form. Then you have your payment schedule. The payment not necessarily will be at one stroke. You will have installments, so you will put down those installments, and also the acceptable payment methods. And then thereafter, in the event if the installments are not paid in time, what happens? So you have your interest clause, or you will have a penalty or a forfeiture clause. Then comes the conditions for completion of sale and the rights and obligations of the party. So this section will basically have your conditions precedent. That means all the conditions and obligations that need to be followed or complied with before your actual transfer takes place. This could include obtaining necessary approvals. In the case of a flat, it could be NOC from the society. In the case of a property owned by a public trust, it could be charity commissioner. In the case of a lease from BMC, it could be BMC, NOC, or in any other lease, it could be the lessor's NOC. Then it has the right of the purchaser to investigate title, which would include raising of requisitions and the vendor's obligation to answer to those requisitions. We will come to that in the second bit of today's lecture. Then you have the vendor's obligation to make out a marketable title and to clear all existing encumbrances on the property. And after that, any other terms and conditions that may be, that those need to be satisfied before the transfer. Then after that, you have your declarations, representations, and warranties. So when we come to investigation, we will talk about how you take a search and how you find out whether there are any registered documents, encumbrances, sales in respect of a property. But not everything you can find by taking a search. You may be able to find a suit, but if there is a notice, you will never know unless unless the owner represents that to you. So those declarations and those representations, so far as the property is concerned, are covered in this declarations and representation warranty clause. Declarations and representations like the vendor has not received any notice of acquisition, there is no pending litigation, or there is no mortgage. There is a possibility that the vendor may have entered into an MOU or an agreement with somebody else, which is not registered. Then you are never going to be able to, as a purchaser's lawyer, be able to find out whether there is another agreement or not. So these will all form part of these representation clauses. Then, of course, that would include the seller's warranties and representations regarding title, etc. Then you come to the payment of taxes. Every immovable property, as you know, has property taxes, etc. to be paid, or there could be lease rent. So you will have a clause to say that up to this date, the vendor has paid and shall pay, and thereafter who is going to pay up to what and who is going to pay thereafter. Then you come to the indemnity, that the seller will give the purchaser an indemnity so far as the title is concerned. And then how the completion of the transaction is going to happen. This will basically outline all the steps that are involved in the completion of the sale, which would include the payment of the balance consideration, the handover of possession or delivery of possession, and the execution of the final document of transfer, which could be a conveyance, which could be a sale deed, which could be a deed of transfer. Thereafter, you have your termination clause. In the event of breach on the part of any party, or the failure to fulfill conditions precedent, or in the case of a force majeure event, what are the consequences? How will you terminate? If there is a forfeiture clause, then that will come, or refund, or sometimes in the event that the refund is not done, there is a charge on the property. So all of that is covered in the termination clause. Thereafter, you have your dispute resolution. Now there are multiple ways that you have for dispute resolution. These are the ones that are available. You can pick any, or you can have one or more. There is negotiation, where parties attempt to resolve disputes through amicable negotiations and talks. Then there is mediation, where a neutral third party may be involved to facilitate communication and help the parties reach to a solution. Then, of course, you have your arbitration, which is a formal process where a neutral arbitrator is appointed and hears both sides and makes a binding decision. And, of course, as a last resort, there is legal recourse to litigation and going to a court of law. In this section itself, the parties may agree to a certain way of dispute resolution, and you put that in accordingly. Then, of course, you have your stamping and registration, where you set out who is going to pay the stamp duty and registration charges, and also that the parties will go and register the document within the time frame under the Registration Act, which is 4 months. Then, of course, you will have general provisions, which would include severability. If any of the provisions of the agreement are found to be invalid or unenforceable, the remaining provisions will remain in full force and effect. Then you have the clause that states that the agreement constitutes entire understanding between the parties with respect to subject matter and supersedes all prior or contemporaneous communications or representations. Then your notice clause, where you put the addresses and also state how notices are to be sent to either parties. The governing law, assignment, whether the benefits or obligations under the agreement, whether the parties are entitled to assign to a third party or not. You have your waiver, and then of course you have a detailed schedule of the property, detailed description of the property, and preferably you should always annex the plan of the property so that in future there is no dispute with regard to the exact boundaries of the property. Now, that is so far as a general agreement for sale for immovable property is concerned. Now, let's talk about agreement for sale of a flat. Now, earlier, of course, we had all these agreements for sale of flats under the MOFA, which is Maharashtra Ownership Flat Act. Now, they all come under RERA, which is the Real Estate Regulation and Development Act. Under MOFA it was section 4, under RERA it is section 13 that says that the promoter or developer cannot take any advance unless and until the agreement for sale is stamped and registered. Now this kind of an agreement for flat is only when you are buying from a promoter or developer. Thereafter you also have resale. Okay? Of course your RERA agreement, there is I think going to be another lecture for RERA, so that will be covered under that. Then when you are going for the resale of flat, which means that you are not directly buying from the developer or promoter, but you are buying it from somebody who has bought it from the developer or promoter or a purchaser from such person. So under resale, there are two things. One is where the ultimate body is already formed. Ultimate body as in there could be a society, there could be a condominium, or there could be a company. And the other is where the ultimate body is not formed. So where it is not formed, the details of the purchase and everything are with the developer. There you do not actually, the ownership is impartible, you do not actually own the property, but you have a right to become a member in the ultimate body. And so far as transfer of this kind of a premises is concerned, the transfer will involve the transfer of all rights in the unit, including the rights and benefits of the earlier agreement or the RERA agreement or MOFA agreement. So far as a society is concerned, now what happens in a society is that as a flat owner, you do not own the premises. The property is always owned by the society. Similarly, in a company and society is more or less similar. So in a company or in a society, the society is the owner of the land and building. So your flat is not actually owned by you. The flat is owned by the company or the society. But you have shares in the society or you have shares in the company by virtue of the ownership of which you are entitled to use, enjoy, occupy and possess the premises. So far as a condominium is concerned, you actually own your unit. You are the owner of your premises along with a proportionate share in the common areas, in the building and in the land. So when you are making a document for a company or a society, what you essentially make is a document for transfer of the shares along with consequential benefits in the premises. When you are making a deed of transfer for the condominium, you will actually make a document which will transfer the rights in the unit and proportionate share in the land, in the building and including in the common areas. So now, what are the documents that you will actually execute when you are doing a flat or a premise transfer where there is a society or a company? You will obviously have your share transfer agreement where you will transfer, like I said, the shares and consequential benefits. You will have the actual transfer happens by the society transfer forms, whereunder you actually transfer your shares to the purchaser. So you have the society transfer forms. Then you have to get the mutation of the name on your share certificate and the records of the society. And you have to have the name change in all utility bills, whether it is your gas or your electricity. In a condominium, you make a deed of apartment or you make a deed of transfer of apartment, whereunder you are actually transferring the apartment along with proportionate benefit in land and building. So that document will be like a conveyance. You have to transfer the name in the mutation card. Now what happens in the mutation property card? Now what happens is, because you are an owner in a condominium, you are also entitled to an undivided share in the land. And because you are entitled to an undivided share in the land, in the property card, which is a government record, your name will come as owner. While where there is a society or company, because the society or the company is the owner of the land and building, in the property card you will only have the name of the society or the company. And of course you will have to again in this case also change the name in the utility and tax bills, but here you will also change in the property card and in the records of the condominium. Now where there is no ultimate body, where do you go to change? You go to change it in the records of the developer. Why? Because eventually developer has to form the ultimate body, developer will give the details, and accordingly, whether it is a society, condominium company, the documentation will accordingly happen. And here also again, change of name is the utility and tax bills. So that is so far as agreement for sale is concerned. Anybody has any questions? Yes?
Landowner confirmation is required. Suppose if I am directly buying from a developer, okay, it's the first instance. So when a landowner confirmation required in light of the Tulsidas Court judgment, because there are situations, because what happens, the landowner may have just given development rights. He may have conveyed the land to the developer. So in that situation, the landowner has to join as a conforming party in my flat agreement.
Not necessarily, because you will have a development agreement which is stamped, which is registered, which will entitle the developer to actually sell the premises in his own name. So therefore this will actually come under your investigation when you are buying a flat with investigator title. These are the documents that you need to see and check what rights are there with the developer.
This is you are talking in case of a sale where I am purchasing. Suppose in case if I am a tenant and the landowner does not give me atonement letter, okay, then in that case, suppose if he has given only development rights to the developer, so shouldn't that landowner join as a confirming party?
So there are two things. The landowner has given development rights. Landowner remains a landowner. If you are a tenant, you will continue to be the tenant of the landowner.
Correct.
The developer has nothing to do with that.
But when
the
I sign-
developer will execute a permanent alternate accommodation agreement.
Correct.
So there it is in your development agreement, you have to check whether the developer is entitled to execute permanent alternate accommodation agreement. And then with the developer you are entitled to execute.
Suppose if there is a termination clause in the development agreement, suppose there is a dispute between the developer and the landowner, and I sign the agreement with the developer
As a tenant.
without the confirmation of the landowner.
No, so if your DA provides a clause that the developer is entitled to, then the landowner is bound by it. There is no question. Anything else?
Where there is an agreement for sale entered under RERA with the developer, and there is a possession letter subsequently on the completion of the project, is there a necessity to do a sale deed or a conveyance deed, or is that
No, for direct purchases from the promoter or developer, your RERA agreement is enough. It is required to be stamped and registered under section 30. That is enough. Yes?
Sometimes there are.
Sorry, I'll just explain to you why also that is enough, because eventually the transfer of the property will happen to the ultimate body. You are not going to have a transfer of the premises to unless it's a condominium. In that case, when the section 2 under the Apartment Ownership Act declaration happens, that time you will have a deed of apartment in your favor. So at that stage, the actual deed of transfer will happen. Sorry.
Sometimes there are two words used interchangeably: agreement to sell and agreement for sale.
Yes.
So is there a difference? And if there is a difference, what is the difference? And basically, because in not in maybe in the Transfer of Property Act, but in some other statutes, the word agreement to sell is also used. So what is the
This is a
difference?
very common question. Anybody would like to answer that? So basically, an agreement to sell is where you are agreeing to sell in the future. Where an agreement for sale, where in some cases, like your RERA agreement, your sale is happening today. Your eventual transfer of the property may happen at a later stage, but your actual sale is happening today. And for an agreement to sell, you are agreeing to sell in the future. That is the essential difference.
But so there are two questions. One question came from the back: is it like a enforceable contract? And
Yes.
the second thing is, there aren't some agreements for sale, agreements to sell also.
Yes, it is a very fine thin line, but they are both enforceable contracts. Yes.
In the case of flat sale between vendors, and vendors are the flat owners. So if agreement to sale is not entered, but instead of that memorandum of understanding, if they, what is the standing?
So memorandum of understanding is basically an intention of the parties to enter into an agreement for sale or enter into any further document. Strictly specific performance you may or may not get, but now there are judgments where you are, if the interest, the transfer of interest is clearly mentioned, the terms are clearly mentioned, there is a possibility of getting specific performance of those MOUs. But otherwise, only in an MOU it will become a money that you are entitled to, or damages that you are entitled to. You may or may not get specific performance. So even if you make a memorandum of understanding, you have to ensure that it is a proper detailed memorandum of understanding where you know all terms, everything is frozen very strictly.
Then in short, we can say it is better to enter into an agreement in terms of immovable property.
Yes.
Yes. Right.
Yes.
Not to go for MOUs.
Enter into an agreement for sale, pay stamp duty, and then register it, because eventually when you do your transfer document, you will get that benefit of the stamp duty that you have already paid. While an MOU you cannot register.
Thank you.
Yes?
Another thing which I wanted to ask was, under the MCS Act, the competent authority is a registrar.
Yes.
Okay, and similarly under the Maharashtra Ownership Apartment Act, the competent authority is the registrar. But why is that the registrar of cooperative society is unaware that he is also a competent authority?
I cannot answer that question.
No, that I have faced it. Practically
yes.
I have faced it, that's why I am asking
Issues,
you.
yes.
So it's dysfunctional actually in a bit.
Yes,
So-
practical issues that hopefully will
And
resolve.
another thing, generally what I have seen in even that marketable title nowadays, I should not think, they put subject to and finally say they marketable.
So if you go through,
So they don't put it in
yes.
black and white,
Yes.
whether it is a market. I mean, today if I am a purchaser, I don't know whether it is really marketable or not, subject to so and so. So it's very,
Yes, now, unfortunately, in
Treacherous.
today's day and age, to get very, very clear and marketable title is also difficult with the way things are. But if you see Justice Daruka's judgment, and I will, tell you all about it when we come to investigation of title.
Tulsidas court of judgment
Yes,
is also
that
very
is the
vague.
one.
also.
But that clearly says that a title certificate can always be conditional. It is not compulsory for an advocate or a solicitor to issue an unconditional title certificate. So when you put in those conditions, any purchaser is aware of the issues and can always ask the vendor to try and sort out those issues and safeguard himself as much as he can.
I have one question. I think more because of this project. And of course I want to prove myself. When you say agreement for sale, when you promise possession is when you have to pay stamp duty.
Yeah.
But if possession is promised at a future date, stamp duty under the Stamp Act will not pay. However, if you register the agreement, you are creating rights in favor of a purchaser. And if the purchaser doesn't perform, then you have the only remedy that you have is to litigate to cancel the agreement for sale. So by doing an agreement for sale which is stamped and registered, you are kind of putting an encumbrance on your title.
No, but either way, whether to enter into a stamped and registered agreement for sale or an unstamped agreement or an MOU, in that sense you are already putting an encumbrance on on your title. So whether it is registered or not, even if it is not registered, it will come in your rep clauses, in your representation clauses. So that is anyways going to be there. The only difference is here you may have to register your cancellation.
Correct. And you may have to litigate to register. Otherwise,
Either way, you may have to
avoid-
litigate.
You may be able to avoid an injunction if it's
Not registered. But then it depends, it could fall either way.
Correct, correct.
So,
Correct. And you spend it,
Yes.
can always get
Yes.
it.
Yes.
Okay. Thank you.
Shall we take a bit before investigation can go in one.
Sure, sure. So basically we have some tea and coffee. So we thought to see the attention span don't deviate. We can take a break for 5-10 minutes and then we can continue with the second part. So I think it is possibly outside. There are some biscuits also. Get up, come back and take it.
Let's start with investigation of title. What is title? Anybody would like to answer now that you are all refreshed? What do you mean by title to a property? Yes?
Right to ownership.
Sorry, I can't hear.
Right to ownership of the property.
Yes. So title is the ownership of property. Now when we are talking about title or a transaction of title or of property or a transaction of sale of property, it is the purchaser's responsibility to verify and investigate the title of the vendor and the vendor's responsibility to make out a clear and marketable title. Now once you have an agreement for sale, what is the process that happens after your agreement for sale up to your conveyance? You start with an accountable receipt under which the original documents are given by the vendor or his advocate to the purchaser to go through those documents and verify the documents. So after execution of the agreement for sale, the vendor himself or his advocate is required to send the purchaser's advocate the original title deeds of the property to enable the purchaser's advocates or solicitors to verify the title of the vendor, and the documents are given against the purchaser's advocates executing and handing over to the vendor a receipt which is known as an accountable receipt. Now why is it known as an accountable receipt? Because the purchaser's advocate is accountable for it. Those documents are given to the purchaser's advocate to verify title, but on demand by the vendor, the purchaser's advocate is bound to return those originals without claiming any charge or lien on those documents. The accountable receipt records that the title deeds are received which the purchaser's advocate undertakes to return to the vendor or his advocate on demand without claiming any lien for costs or otherwise. Once the purchaser's advocate executes the accountable receipt, it becomes the responsibility of such advocate to preserve the title deeds. Now let us see what an accountable receipt would look like. So you have the description of the property in your reference and the name of the vendor and purchaser. Received from, you put the name of the vendor or his advocate, the undermentioned title deeds relating to the above property which we undertake to return to him on demand without claiming any lien for our costs or otherwise howsoever. Thereafter you will list the title deeds which are received, dated so and so date, and advocates for the purchaser and the full address. Now in today's day, as a practice, a lot of the solicitors and advocates do not follow this process. They only inspect the original documents from the vendor. But the correct way of doing it is to take documents on an accountable receipt, go through each and every document, verify them, and then thereafter return them to the vendor against taking the receipt back. This is, in fact, I believe this question comes very, very often to draft the accountable receipt. If you all see your papers, I think it's a very popular question. Let's go on to investigation. Now, once you have the documents, you have the original documents as a purchaser's advocate, what do? You review the documents. Now, what will you review in the documents? You will see the chain of documents. You will see the title flow. When do you see the title flow from? That is known as the root of title. What is root? Root is the starting time from where you will see the title. Generally, it is 30 to 40 years. So you will go back 30 to 35 to 40 years in time and start from a document which is 30 or 40 years old, and then get the flow of title from that date, A to B, B to C, C to D, and ensure that the flow is correct. Why 30 years? Why is it that 30 years is a good root of title? 2, 3 things. Because one, where there is a mortgage, the limitation for redemption or foreclosure is 30 years. If there is a suit to be filed by the government or on behalf of the government, the limitation is 30 years. So if you go 30 years back, then you know that you are covering everything that is possible to come in the way of a clear title. So root of title is the starting point of investigating the ownership history of the property. It is usually 30 to 40 years old. One should ideally trace back the chain of the documents up to 30 to 40 years because under Limitation Act section 61A, the period for limitation for redemption as also for foreclosure of a mortgage is 30 years. Further, the limitation for any suit by or on behalf of central or state government is 30 years. Now, what are the documents that you will see when you are looking at the chain of documents and when you are investigating title? When you are looking at purchasing a flat, the documents you will see are the entire chain of agreements for sale or your deeds of transfer. You will see the index 2. Does anybody know what an index 2 is? Yes.
It is a record maintained by the sub-registrar of whatever documents have been registered.
Correct. So once you see an index 2 of a document, you know that that document has been duly registered. So you verify each document with the index 2. Then you will see the share certificate if there is one, if it is a society, and see whether the flow is matching with your title documents. So if the share certificate has A's name first, thereafter B, C, then you have to ensure that the documents also flow in that order. Or if there is a death, you have to see how the title flow, how the succession flow is happening. Then you have the details regarding parking of cars. You have to check whether there is an NOC from the society for the transfer of shares. You have to check whether there is a no dues certificate and a no lien certificate. No dues certificate is basically a certificate that the society gives saying that there are no dues pending on the name of the member. And a no lien certificate is basically a certificate that the society gives stating that in their records there is no mortgage charge or lien so far as the shares of flat are concerned. Then you have to check the last maintenance bill, your electricity bill, property tax bill, and of course the occupation certificate. Occupation certificate is basically a certificate from the MCGM or the BMC that certifies that the building is fit for occupation. You have to ensure that there is an occupation certificate if your client is buying a flat. Otherwise, it is a criminal offence to occupy a flat where there is no occupation certificate. So that is one document which you need to see. Then when you come to a plot of land, what are the documents that you will look at? Of course, you will look at all the chains of agreement for sale. You will look at the conveyance. If there is a lease, you will look at the lease. Again, you will check that and verify that with the index 2. You will look at the property card, which is a government record, and see if the name of the vendor is there in the property card. Or you will look at the 712 extract, what is known as a Sat Bara, which normally you will find in the towns like a Khandala or second tier towns, not in the city. In the city you do have Sat Bara, but they are old. Now they have done away with Sat Baras, now you have the property cards. Then of course you will look at the DP, what is known as DP remarks or development plan remarks. So these DP remarks will basically tell you if the property is under any reservation, or if there is a road on the property, or if there is a road abutting the property. So that is what you need to check. Or if there is a town planning scheme in where the property is, then you have to look at what is known as the TP remarks or the town planning remarks, which again will talk about whether there is a reservation, a road, etc. Also, you have to look at the Kami Jasti Patra. Now, does anybody know what a Kami Jasti Patra is? Yes.
Increase or reduction in the area.
Correct.
It's a kind of reconciliation
Correct.
papers. So we have the old survey numbers, and then now because
We have the old survey numbers you are in the city of Bombay, the island city of Bombay, the property is given what is known as a cadastral survey number or a CS number. But in the suburbs, it is the city survey number or the CTS number. So anytime that you look at the description of a property, when you see a CS number, you know that the property is within the city of Bombay. When you see a CTS number, it would be in the suburbs. So beyond Mahim and I think beyond Matunga on the central side. Sion or Matunga on the central side. So you will look at the Kamijasti Patra. Also you will look at the Form 1, which again is now, if there is a town planning scheme. Like you have the Kamijasti Patra from survey to CS and CTS. You have a Form 1 from CTS and CS to the plot number, where there is a town planning scheme, you have plot numbers. So that is your Form 1. Then of course you will look at the MCGM assessment bills and the property tax bills, and you will look at the plans. So that is so far as a plot of land is concerned. These are the basic documents that you will look at and verify for in the process of investigation of your title. Now in each document, what are the things that you have to check? Is you have to check so far as the recitals are, the names of the parties are concerned, what capacity they are executing in, whether the recitals are in order, then you see the description, the operative portion, if there are any restrictive covenants, because that will be binding on your client as a purchaser, if there are any restrictive covenants which run with the land. Anybody has any example of restrictive covenant? What are the kind of restrictive covenants that could, yes?
Could it be a covenant for allowing right of way or
Yes.
easementary rights?
Absolutely, absolutely. So there could be an easementary right to be adjoining property from your property, in which case if your client is eventually purchasing the property to develop the property and he has to keep a certain portion open for right of way, you need to know that. So you have to check for any kind of restrictive covenants. There could be a covenant for production of title deeds. There could be, then you need to check on the particulars of stamp duty, ensure that all the documents are duly stamped, duly registered, and ensure that all the documents are properly executed and attested. Attested meaning witnessed. Now, this is a little out of portion. What are the documents that really need necessarily to be witnessed? There are only 3 types of documents. The rest is completely upon the person whether you want to witness it. Yes?
I'm aware of 2, of gift
Yes.
and will.
Yes. And a mortgage. These are the 3 documents that you need duly witnessed by 2 people. For an agreement for sale, strictly legally does not require any kind of witness. For a conveyance also, strictly legally does not require witnesses, but as a practice you have witnesses, so that in the event there is any litigation, you have somebody as a witness who can go into evidence, go into the box and give evidence with respect to the document execution. Yes?
Leave of license, there is a mandatory witness sign.
Yes, that is for the registration purpose. In law, it is not required. Now, of course, when you are looking at the documents, you need to see whether all the prior transfers are compliant with law. So, like I said, whether it is stamped, whether it is registered. Now, sometimes documents are executed through a power of attorney. In that case, you need to first check whether the power of attorney gives the attorney the power to sign and execute or not. That is one thing you need to check whether, and secondly, you have to check if the power is duly stamped and registered. Otherwise, the document will be a document which is not a proper document. Then you have to also check whether necessary permissions and NOCs have been taken. Like I said, in a public trust, you need charity commissioner's permission, etc. Those permissions which are required, you have to ensure that those permissions are taken. So that is so far as your checking of documents or verification of all the documents is concerned. Now, once you do that, you need to give a public notice. Okay? Why a public notice? Because you are inviting claims, you are letting the people in general know that you are investigating this person's title, and you are inviting claims from public at large if they have any right in the property, if they have any claim in the property. They come in, they write to you and they inform you of the claim. Normally, you give public notices in 2 newspapers. One will be an English newspaper and the other one in a vernacular paper. Preferably, you give it in a vernacular newspaper in the language of your vendor or in the language which is commonly used in the area where the property is, so that if there are any claims that are going to come, they will come before you are going through with your transaction. This is what a public notice looks like. I'll just read it out. Notice is hereby given that under instructions from our clients, we are investigating the title of so-and-so residing at blank as the owner of the undermentioned property. Now, this is very, very important because a lot of times in practice, you will have vendors, we have had it very often, vendors coming and telling you, we don't want to put our name, we don't want to put our address in a public notice, which you cannot do because unless the vendor's name is there, if any person has a claim, he may or may not be able to recognize that. So the vendor's name is very, very essential and the description of the property has to be there. Any person or persons having any claim, demand, share, right, title and or interest of any nature whatsoever in the undermentioned property or any part thereof by way of any agreement, sale, transfer, mortgage, charge, lien, encumbrance, gift, bequest, release, exchange, easement, right, covenant and condition, tenancy, right of occupancy, assignment, lease, sublease, legal license, partnership deed, loans, use, possession, partition, trust, inheritance, outstanding taxes and or levies, outgoings and maintenance, attachment, injunction, decree, order, award, list pendants, and or by virtue of the original documents of title being in their possession, custody or otherwise in any manner howsoever and whatsoever are required to make the same known in writing, along with certified true copies of documentary proof to the undersigned having their office at blank, within 14 days from the date hereof, otherwise the same shall be considered as waived. And then you put the details of the property and your signature. So basically you have to give a 14-day public notice in 2 newspapers. Thereafter you of course have your various searches that you take to ensure that there are no other documents, there is no litigation. Now what are the searches that you can take? You have many search clerks who do the searches in the sub-registrar's office. So you will take a search of at least 30 years. Why 30 years? Because 30 years is good root of title. So you will take a 30-year search in respect of the property in question with the sub-registrar of assurances, and to ensure that there are no other documents which are registered with respect to the property and the flow is going with the flow of the documents that you have. Then you will do what is known as a cell-size search, which earlier was not there. Now, fortunately, we have the benefit of a cell-size search, which is for checking of mortgages. Then you have the negative index search, which is essentially a litigation search, which you can do on the High Court site. You can do it for High Court, do it for City Court, do it for NCLT, and ensure that there is no litigation pending. If there is, if you find in your search that there is a litigation pending, you can always call for those papers and proceedings and verify whether and advise your client accordingly whether it is okay to proceed or not. And in case if the vendor or seller is a company or a partnership or LLP, trust, then you have to have a search. In the case of a company, you do the company search with the MCA. In the case of a partnership firm, of course, you have an ROF or a registrar of firms search. In the case of a trust, you do a search in the Charity Commissioner's office to see whether the property is shown as a property of the trust and whether what transfers or what is there in the records of the Charity Commissioner. Now, after you've done that, now you have your searches, you have your documents, then you raise requisitions. As a purchaser's advocate, it is not compulsory and mandatory, but you can, if you would like to, you can raise requisitions on title, which the vendor is bound to answer for you. So you will raise requisitions of title, which would include various questions. Now there are 2 types of requisitions. One is general requisitions, and then there are special requisitions. General requisitions are standard requisitions, which are questions like whether the exact description of the property, whether there is any mortgage, whether there is any other encumbrance. Special requisitions again would be specific requisitions to the property. So if there is say succession involved, somebody has got the property in inheritance, then you need to check whether the succession law is there or not. You need to check whether there is a will. If there is a will, whether it has been probated. If it is probated, whether there is a deed of transfer in favor of the beneficiary. So all of these you can ask the vendor in the form of requisitions. Now, like I said, administering requisitions is a matter of right that the purchaser has, but he is not obliged to do so. Responding to the requisitions is an obligation of the vendor under section 55(1)(c) of the Transfer of Property Act, and the seller is bound to answer these to the best of his information. Now, what happens if the vendor refuses to answer the requisitions? The purchaser can terminate the agreement and go ahead with cancellation of the agreement, and obviously then the terms of the agreement for sale will follow. If the vendor is unable or unwilling to answer the requisition, and if there is a clause in the agreement permitting him to do so, then he can decline to answer the requisition and then terminate the agreement unless the purchaser withdraws the question. So sometimes the purchaser may say, okay, you are not able to answer this, that is alright, I would still like to go ahead with the transaction. So in that case, you will still go through. Once the title is acceptable, then finally you proceed with the document for transfer. That is your final conveyance or your deed of transfer. So this is what basically is covered under investigation of title. Just last few points that you need to consider in specific cases. Now, if your owner or vendor is a partnership firm, what are the things that you need to check? You need to verify the names of all partners and ensure that when you are making the document, all the partners are executing the document. Now, why do you need all partners to execute document? Anybody? Like if you have a company, you are not going to have all shareholders sign. But in the case of a partnership firm, you will have to have each and every partner to sign the document. Why is that so?
So that nobody alleges that this was done without my consent, or basically doesn't. Some partner who has a dispute with other partners does not raise a dispute in the future.
Right, but that can happen in a company also, right? A shareholder may say that.
Or there is another person.
Or that's the answer. Because a partnership is not a legal and juristic person. The property is held by the partners for the firm, while a company is a legal entity in law and can hold the property in its own name. So therefore, you need to ensure that all the partners are signing the document. Then, when you have a public trust, you have to verify the trustee. You have to whether the trustees have a right to sell. You have to ensure that there is a charity commissioner's permission. You have to check the resolution, and you have to ensure that all the trustees are signed. Because again, the property is held by the trustees and not the trust in that sense. Same thing for the private trust. Again, you verify the trustee and check if the trustees have a power to sell. All trustees should sign, and if possible, all beneficiaries should also execute to avoid challenge. If it is a company, you have to check the resolution, you have to check for winding up and insolvency proceedings, and you have to take necessary declarations and representations, and you have to also check the memorandum and articles of association. In the event of an HUF, you have to ensure that the karta and all members and co-partners should execute the document. It is always better to have all members signing your document so that in future there is no challenge by any of the members. You have to ensure that there are no minors in the HUF. In the event there are, you may have to show legal necessity, or you may have to take court permission, and you have to also verify legal necessity. Now, sometimes, especially in the event of a flat, you have a nominee who is shown as an owner. So when you are looking at the documents, you have to ensure that the owner that you are dealing with is not merely a nominee, but is the actual owner. Because the society, for its own purposes, may transfer the share to a nominee, but nominee is only holding the property in trust for all the actual heirs. So you have to ensure that the owner is not a nominee, but is the actual owner. And of course, if there is a will, then you have to check if there is if the will is probated, and the executors and beneficiaries should all execute the document. And if there is a deed of transfer made after the will is probated, so the process is you have a will, you get it probated, and then the executor will transfer the property to the beneficiary by a deed of transfer. Now, if the deed of transfer is executed, then only the beneficiary may sign, otherwise the trustees and beneficiaries need to sign the document. So that is so far as investigation of title is concerned. Now, what is a marketable title? Once you have seen all of these documents, how do you decide whether the title is marketable or not? Marketable title is a title which may at all times and under all circumstances be forced upon an unwilling purchaser. A doubtful title cannot be forced upon a purchaser. So like I said, once you have gone through all these processes, you have verified documents, found them in order, you have given public notice, you have not received any claims, you have checked whether everything, all the documents are there, and you decide that yes, you've taken the searches, not found anything not ordinary in the searches, then you can go ahead and say that the title is absolutely clear and you can proceed with the transaction. Now, when can you consider a title doubtful? Where there is litigation, where the ownership is challenged, where there is an existence of an unpaid, these are only a few examples, where there is an existence of an unpaid mortgage, or where any preceding title is in contravention of any law. Then in these kind of cases, of course, your title is not going to be marketable, and you will advise your client not to buy the property, or you will ensure that the vendor clears these things before your client can proceed with completion of the transaction. So that is, I think, covering everything so far as investigation is concerned. Any questions, anyone? Yes.
Now, in case of a buyer, I mean a buyer purchasing a new flat from the promoter directly. Okay, in that case, do we have to do all this thing because it incurs a lot of money?
Right. So in the case of a buyer and you have your RERA agreement, normally it is the title certificate is already attached to the RERA agreement. So somebody has already done this investigation for you. Under RERA, it is compulsory to have a title certificate attached to the RERA agreement. So some lawyer has already done that process for you. So you don't need to really go into that unless a long time has passed and it is a very old certificate. Then it is advisable that you do. But if it is a recent title certificate, that person would have gone through this entire process before getting the title.
Thank you.
Can you explain what
Sorry, can you take the mic, please?
can you explain what forced upon an unwilling purchaser would be?
I'm sorry, what?
In the definition of marketable title, I didn't understand what would forced upon an unwilling purchaser mean.
So when you have a transaction and the purchaser is not willing to buy the property, you can force the purchaser because your title is clear. So the purchaser has no other reason to get out of the transaction because your title is clear. What is the seller's responsibility in any transaction of sale? The seller's responsibility is to hand over possession and to give the buyer a clear title. So that is what a marketable title is. You can force it on your purchaser. Yes.
If the buyer starts investigating the title and finds that maybe 30 years ago, so before the limitation, there has been, let's say, an HUF, and they didn't consider the minors or they didn't consider signatures of all the co-partners. So essentially, the document was not exactly precise in the title flow. So what happens then after 40 years? Can that person go ahead?
So what happens is that, which is why you think 30 years is root, right? So if there was an HUF and all co-partners were not made parties, or there was a minor, then the minor can, on attaining majority, challenge the transaction. Now the limitation for that period is already gone, which is why we say 30 years is good title generally, because even if somebody files a suit, it will be barred by limitation.
And in case of it, which is probated, is it compulsorily required that to execute the formality of transfer between the beneficiaries and the?
Yes, otherwise if it is not executed, you make the trustees sign and make the beneficiary a confirming party. because the property vests in the executors. It will only come to the beneficiary once your deed of transfer is done. Yeah.
Madam, what is the necessity for both the partners signing? Because, please correct me if I'm wrong. Because under the Partnership Act, all the partners are jointly and severally liable for their acts of omissions and commission. Suppose if one partner signs a particular agreement, isn't the other partner equally liable for this act?
See, so like I said, a partnership firm in itself cannot hold property. So if there are 4 partners, the property is held in the names of the partners. So each partner in that sense has 25% or 1/4 right in the property. Unless that partner is signing the document, how will his share be transferred? Anybody else? Are we good to write a paper on investigation and agreement to sale? Alright. Thank you so much. You have been wonderful.
Just 2 seconds. We have to felicitate her for giving us this very knowledgeable lecture, and we have to thank her for giving us so much of time. That we agree.